Last week, lawyers came so close to being barred from ever using Zoom again, it's incredible. Now, this is a lesson that you need to know. It's not clickbait. If you're a lawyer, you need to listen to this because it's going to save your career. Now, look, I know you usually don't listen. Oh, come on, stop. Stop. Stop making it seem like you actually. Why are you trying to convince me otherwise? You know, you're embarrassing yourself. I mean, come on. I see the analytics. I know that I get 30 seconds of listen time if I'm lucky. I get it. It's ethics. It's boring. And let's face it, I can be a bit much. But this one could seriously save you from an ethics violation because it's an issue that's far bigger than just Zoom. All right. Last week, Zoom announced that it was changing its terms of service. It was going to start using consumer data to update and train its AI. It said that messages, files, and documents were not going to be included in that information, but it was unclear if video calls would be used. CBS News reported a scientist's tweet, and that tweet read, quote, Zoom's terms of service now demand that they use AI to train on audio, face, and facial movements, even private conversations without recourse, unconditionally and irrevocably. Opting out is not an option. So what happened? Well, the entire world went nuts, and Zoom was forced to issue a clarification. Zoom explained, quote, Zoom does not use any of your audio, video, chat, screen sharing, attachments, or other communication like customer content, such as polls, whiteboard, and reactions, to train Zoom or third-party artificial intelligence models. Is that what they really intended all along, or was their updated terms of service going to broaden the data they use to train their systems? I guess we'll never know. But here is the lesson. If you didn't realize that there was a proposed change, you should be worried. And if you realize there was a proposed change, but you didn't realize you should be concerned about it, you should also be worried. If you didn't realize that there was a proposed change, it means that you're not reading the right websites, you're not reading the right news outlets, so that you could learn about critical changes that could affect the practice. There were enough people yelling and screaming about this. You should have heard about it. And that's important because we have to make sure we stay abreast of the changes in technology. We've got to make sure we understand how things change, potentially to our detriment, if we're going to stay competent. If you heard about it but didn't get concerned, then you aren't aware of the considerable ethical dilemma that this change could have posed, or actually did pose. You need to understand why it was such a monumental problem and how it affects lawyers' use of all technologies, not just Zoom. And it goes back to confidentiality. Lawyers have to keep client information confidential. The information that lawyers need to keep confidential is defined very broadly. If you look at Rule 1.6, it says that it's information related to the representation. That's the standard in the rule. Not every jurisdiction, but most. But that's not the only standard to keep in mind. The other one goes back to our use of email. Yes, give me just a minute to talk about the history here. Now, I know what you're thinking. How do you make a podcast about ethics even more boring? You make it the history of ethics. Just give me a second. When unencrypted email first came on the scene, lawyers couldn't use it. And that only changed when Congress criminalized the interception of unencrypted email. Only after that were lawyers considered to have a reasonable expectation of privacy in that technology. There was a case a few decades later that showed that the reasonable expectation of privacy continued to be important, and it continues to be important today. It's got to do with Gmail. Years ago, Gmail stayed free by relying on advertising. The system read through emails that were being sent, and then it spit an ad out on the recipient's end that was tailored to the content of the email. The theory appears to be that there's a greater likelihood the recipient will click on that ad if it's relevant to the content of the email. You see the problem, right? If Gmail is reading our emails, then how do lawyers have a reasonable expectation of privacy? Well, New York considered that in an ethics opinion, and they said, it's okay. Why? Because no human ever read the emails. It was only reviewed by Gmail's computers. Therefore, the opinion held lawyers still had a reasonable expectation of privacy in using that system. Well, the standard lives on today. Apply it to this proposed Zoom change. Was the information that Zoom would now use to train its systems information related to the representation? And if so, would human beings review that information? You've got to assume the answer is yes to both of those questions. It's very possible that some of the data that Zoom was going to use would qualify as information relating to the representation. I mean, a lot of commentators were pretty up in arms about what was going to be captured. And it's equally possible that humans would be reviewing it. That's the sort of thing that happens when tech companies want to improve their systems. They frequently need actual humans to review the way customers use their content because humans frequently pick up issues that the computers might miss. Now, obviously, we don't definitively know the answer to those questions. Zoom, I'm sure, will say that it was never their intention to look at the content of our calls. But based on everything we read in the media, there's no way any of us could say for sure if the answer to those questions would be a problem for lawyers. What does it mean? It means you needed to look deeper. Your duty of competence, diligence, and probably supervision required you to look deeper and get clear answers. If you read about it and you didn't look deeper, it could have been a huge problem. Once you've been made aware of a problem like this, whether it's about Zoom or any other technology, you need to look deeper. And what that means practically is that when you're faced with an issue like this, you probably need to stop using whatever technology you're using until you have it figured out. Again, it's not a Zoom issue. Every technology company does this sort of thing. They need to improve their systems. They need to train their systems. And they want access to our user data because it's that data that's so vital in allowing them to make the important changes that they need to make. That's why you need to listen for this issue in any context. Of course, there's one other alternative. You could have done nothing. When you heard about this sort of thing, you could have stuck your head in the sand and continued to use technology until you saw some other lawyer get schwartzed. Schwartzed, yeah. You don't know what I mean by that? That's the name of the lawyer who made the huge error of using ChatGPT for research recently and got torn apart by the court for submitting cases that the system made up. Yeah, he was the first person to get in trouble for that, and he taught all of us a lesson. Do you want to be the Schwartz of Zoom or the Schwartz of some other technology? Don't be the Schwartz. Watch out. If you ever hear that some software is using data to improve, train, or whatever, stop using it. Act. Take your client information off until you figure things out. Otherwise, you're going to end up being right next to Mr. Schwartz in the worst place that any lawyer wants to be. You know where that is? Inside a law school ethics textbook.